The death penalty in Texas. In Texas, the district courts have original jurisdiction for all criminal felony cases. If an individual is convicted of a capital felony, he or she may be subject to punishment by death. A capital felony is one in which an individual intentionally or knowingly causes the death of an individual under certain circumstances. One example of a capital felony is murder of a peace officer or fireman who is acting in the lawful discharge of an official duty and who the person knows is a peace officer or fireman. This kind of capital felony then would be punishable by death in Texas. Another capital felony is a killing or a murder committed during the commission of a felony. So murder during the commission or attempted commission of kidnapping, burglary, robbery, aggravated sexual assault, arson, obstruction or retaliation, or a terroristic threat is a capital felony. Another capital felony is murder for remuneration or promise of remuneration, or employing another to commit murder for remuneration or the promise of remuneration. In other words, a murder committed for hire or committed for money is a capital felony. Murder by an incarcerated person is also a capital felony. So this would mean murder during an escape or attempted escape from a penal institution, murder while incarcerated in a penal institution of a correctional employee or with the intent to establish, maintain, or participate in a combination or in the profits of a combination, murder while incarcerated in a penal institution for a conviction of murder or capital murder, or murder while incarcerated in a penal institution serving a life sentence or a 99-year sentence for a conviction of aggravated kidnapping, aggravated sexual assault, or aggravated robbery. Also, capital felonies are murders of more than one person. So the murder of more than one person during the same criminal transaction or during different criminal transactions, but the murders are committed pursuant to the same scheme or course of conduct. Murder of a child is also a capital felony. The murder of an individual under 10 years of age or older than 10 years of age but younger than 15 years of age. A murder committed in retaliation against a judge is a capital felony. So murder in retaliation for or on account of the service or status of the other person as a judge or justice of the Supreme Court, the Court of Criminal Appeals, a court of appeals, a district court, a criminal district court, a constitutional county court, a statutory county court, a justice court, or a municipal court. Texas also has the law of parties, which allows offenders to be sentenced to death if present while a capital crime is being committed, based on the offender being criminally responsible for the conduct of another. After the verdict is rendered, if the defendant is found guilty, the case is automatically appealed to the Texas Court of Criminal Appeals. If the prisoner loses in the Court of Criminal Appeals, he or she may then appeal the case to the U.S. Circuit Court of Appeals, and then finally to the United States Supreme Court. When the entire appeals process has been exhausted, the governor of the state of Texas still may have a limited power to grant clemency to the prisoner. In capital cases, the governor has the constitutional authority to grant an offender one 30-day reprieve of a scheduled execution without a recommendation from the Texas Board of Pardons and Paroles. Upon recommendation from the board, the governor may grant one or more reprieves in a capital case. If a prisoner submits a timely request for a reprieve of execution, the board must determine by majority vote whether to recommend to the governor that a reprieve be granted. If a death row inmate files a timely petition to the board for a commutation of sentence to a lesser punishment, such as life imprisonment, the board will vote on whether to recommend the commutation to the governor. In 2018, the Texas Board of Pardons and Paroles voted unanimously to recommend clemency for death row inmate Thomas Bartlett Whitaker, facing execution. Governor Greg Abbott, a Republican, approved the recommendation to change Whitaker's death sentence to life in prison. The last time the board recommended clemency for a death row inmate before that was 2009, and a Texas governor hadn't approved clemency since 2007. The Texas governor cannot impose a moratorium on executions, as this authority is not allowed in the Texas Constitution. To give the governor this power would require a constitutional amendment approved by voters. The governor has clemency authority on the advice of the Board of Pardons and Paroles and needs a favorable recommendation from the board in order to be able to grant clemency. The governor is not obligated to follow the recommendation of the board, however. The governor also has the power to grant a one-time 30-day reprieve. The governor appoints the members of the Board of Pardons and Paroles. Between 1819 and 1923, Texas executed its death row prisoners by hanging. Hangings were administered by the county where the trial took place. In 1923, Texas required that executions be carried out on the electric chair and that they take place at the Texas State Penitentiary at Huntsville, also known as the Huntsville Unit. In 1977, execution by lethal injection became the legal method of enacting the death penalty in Texas. The first prisoner executed by lethal injection in the United States took place in Texas in 1982. The United States Supreme Court decision in Furman v. Georgia declared Georgia's unitary trial procedure, in which the jury was asked to return a verdict of guilt or innocence and simultaneously determine whether the defendant would be punished by death or life imprisonment, to be unconstitutional on the grounds that it was a cruel and unusual punishment in violation of the Eighth Amendment to the United States Constitution. The ruling essentially negated all death penalty sentences nationwide. It led to a 1973 revision of the Texas laws introducing a bifurcated trial process where the guilt, innocence, and punishment phases are separate, and narrowly limiting the legal definition of capital murder. As a result of the Furman decision, the 52 Texas death row inmates at the time had all of their sentences reduced to life imprisonment. Among them was Kenneth McDuff, who was originally condemned for the murder of 3 teenagers in 1966. He was paroled in 1989, but subsequently executed in 1998 for a murder he committed while on parole, and is suspected to have been responsible for many other killings. Jerry Jurek was convicted of killing 10-year-old Wendy Adams in 1973. His case went to the Supreme Court as one of several testing new death penalty laws around the country. The Supreme Court decision in Jurek v. Texas once again allowed for the death penalty to be imposed. The first execution in Texas after the Jurek decision was on December 7, 1982. In the post-Gregg era, Texas has executed 573 people. By 2021, the usage of the death penalty in Texas courts was on the decline. There were 3 executions in 2020, the smallest number of executions per year since 1996, which also had 3. In 2020, 2 persons were sentenced to death, making it the post-1974 year with the lowest number of people sentenced to death. In September 2005, Texas implemented life without parole sentencing in capital cases. Prior to that, juries had a choice between the death penalty and life in prison, with a possibility of parole after 40 years. Texas is first in the number of executions carried out in the United States since 1976. Texas, the second most populous state of the Union, has executed 573 offenders since capital punishment resumed in 1976, beginning in 1982 with the Brooks execution to September 28, 2021. Texas was the first U.S. state to carry out an execution by lethal injection, executing Charles Brooks on December 7, 1982. One Texas county, Harris County, accounts for over 280 death sentences and 127 executions since 1982. Of Texas's 254 counties, 136 have never sent a single offender to death row. As you can see on these maps, in the last 5 years, one county, Harris County, has imposed 3 death sentences. 2 other counties have imposed 2 death sentences each, and several counties have imposed 1 death sentence. But most counties in Texas have not imposed a single death sentence in the last 5 years. If you go back 10 years, you can see most of the death sentences again are from Harris County, and again, most of the counties in Texas have not imposed the death sentence at all. "13 juveniles were executed in Texas before the 2005 U.S. Supreme Court decision in Roper v. Simmons. The Supreme Court drew the line at age 18 in death cases after the death sentence was given to a 17-year-old Christopher Simmons, who kidnapped a neighbor in Missouri, hogtied her, and threw her off a bridge. Prosecutors said he planned the burglary and killing of Shirley Crook in 1993 and bragged that he could get away with it because of his age. 29 juveniles awaiting execution were sentenced to life in prison and removed from death row in response to the decision. The U.S. Supreme Court prohibited the application of the death penalty to persons with mental retardation in Atkins v. Virginia in 2002. But the Texas legislature still has not enacted statutory provisions governing the standards and procedures to be followed in these cases. On these tables, you can see the record holders for the shortest time on death row prior to execution and the longest time on death row prior to execution. The record for the shortest time is Joe Gonzalez, who was executed in 1996 after 252 days on death row. David Lee Powell from Travis County was on death row for 31 years, 11,575 days, before finally being executed on June 15, 2010. Now I'd like to go over a few famous cases involving death row inmates. Carla Faye Tucker, born in 1959, was convicted of murder in Texas in 1984 and put to death in 1998. She was the first woman to be executed in the United States since 1984 and the first in Texas since 1863. Cameron Todd Willingham was executed in 2004 for arson in a 1991 house fire that killed his 3 daughters. The arson theories used as evidence in his case have since been repudiated by scientific advances, and arson experts now believe the fire may have been accidental. Anthony Graves spent 16 years in prison before being released on October 27, 2010. He was convicted based on the testimony of Robert Carter, who said Graves was his accomplice. 2 weeks before Carter was scheduled to be executed in 2000, he provided a statement saying he lied about Graves' involvement in the crime. He repeated that statement minutes before his execution. Graves' conviction was overturned in 2006 due to prosecutorial misconduct, and the special prosecutor assigned to his new trial dropped the charges against him, saying, "We found not one piece of credible evidence that links Anthony Graves to the commission of this capital murder. He is an innocent man." The case of Randall Dale Adams was a very famous case of a death row case in Texas. Randall Dale Adams was convicted and sentenced to death in 1976 for the killing of a Dallas police officer, Robert W. Wood. In October 1976, a 27-year-old Adams and his brother left Ohio for California. En route, they arrived in Texas on Thanksgiving night. The next morning, Adams was offered a contracting job. On the following Saturday, November 27, Adams went to start work, but no one turned up because it was a weekend. On the way home, his car ran out of gas. David Ray Harris, who had just turned 16, passed Adams in a car that he had stolen from his neighbor in Vidor, Texas, before driving to Dallas with his father's pistol and a shotgun. Harris offered Adams a ride. The two spent the day together drinking alcohol and smoking marijuana. That evening, they went to a drive-in movie. Shortly after midnight, on November 28, Dallas police officer Robert W. Wood stopped Harris's stolen car because the car's headlights were not on. As Wood approached, he was shot twice in the forearm and chest by someone in the car. The vehicle sped off almost immediately after the shooting, giving Wood's partner Teresa Turco little time to react. She later testified that she managed to fire upon the fleeing vehicle, but to no avail. After returning to Vidor, David Ray Harris boasted to friends that he was responsible for the crime. Harris was arrested, but when he was interviewed by police, he accused Adams of the murder. Harris led police to the car driven from the scene of the crime, as well as to a .22 short-caliber revolver he identified as the murder weapon. Dallas prosecutor Douglas D. Mulder charged Adams with the crime, despite the evidence against Harris, apparently because Harris was a juvenile at the time and Adams, as an adult, could be sentenced to death under Texas law. Adams testified that after leaving the drive-in movie, Harris dropped Adams off at his motel, where Adams and his brother watched TV and then went to sleep. He claimed he was not in the car when the shooting happened. Harris testified that Adams was not only in the car but was the driver, as well as the shooter of Officer Wood. Testimony by Harris and several questionable eyewitnesses, including Emily Miller and R.L. Miller, who claimed to have driven past Harris's stopped vehicle immediately before the shooting, led to Adams's conviction. Texas forensic psychiatrist James Grigson, nicknamed Dr. Death, was also a witness for the prosecution. Having conducted a psychiatric evaluation of Adams, he told the jury that Adams would be an ongoing menace if kept alive. As a result of this testimony, Adams was given the death penalty. His conviction was unanimously upheld by the Texas Court of Appeals in 1979. In 1995, Grigson was expelled from the American Psychiatric Association and the Texas Society of Psychiatric Physicians for unethical conduct relating to expert witness testimony. Adams's execution was originally scheduled for May 8, 1979, but U.S. Supreme Court Justice Lewis F. Powell, Jr. ordered a stay 3 days before the scheduled date. In 1980, the Supreme Court, on an 8-1 vote, ruled unconstitutional a Texas requirement for jurors to swear an oath that the mandatory imposition of a death sentence would not interfere with their consideration of factual matters such as guilt or innocence during a trial. As a result of this decision, Adams's death sentence was reversed, and the Texas Court of Criminal Appeals granted him a new trial. Before the trial could begin, however, Texas Governor Bill Clements commuted Adams's sentence to life in prison at the request of the Dallas County District Attorney. In May 1988, David Ray Harris, now also a prisoner on death row, admitted that Adams was not even in the car on the night of the murder. In August 1988, a documentary film, The Thin Blue Line, detailed many inconsistencies in the prosecution's case, further casting doubt on Adams's guilt. In 1989, the Texas Court of Criminal Appeals overturned Adams's conviction on the grounds of malfeasance by the prosecutor, Douglas Mulder, and inconsistencies in the testimony of a key witness, Emily Miller. The appeals court found that prosecutor Mulder withheld a statement by Emily Miller to the police that cast doubt on her credibility and also allowed her to give perjured testimony. Furthermore, the court found that after Adams's attorney discovered the statement late in Adams's trial, Mulder falsely told the court that he did not know the witness's whereabouts. The Texas Court of Criminal Appeals stated that conviction was unfair, mainly because of prosecutor Doug Mulder. Following the appeals court decision, the district attorney's office decided not to prosecute the case again, and Adams was released. Despite being wrongly imprisoned for 12 years, Adams received no compensation from the state of Texas. At the time his conviction was thrown out, wrongly convicted prisoners could get a lump sum payment of $25,000 if pardoned by the governor. However, since Adams was released because his case was dismissed and not because he was pardoned, he received no payment from the state after his release. If Adams had been found to be wrongly convicted under present-day Texas law, he would be entitled to receive $80,000 for each year of incarceration. Adams later worked as an anti-death penalty activist. He wrote a book about his story, Adams versus Texas, which was published in June 1992. In 2001, at an anti-death penalty legislative hearing on behalf of the Texas Moratorium Network, Adams said, "The man you see before you is here by the grace of God. The fact that it took 12.5 years and a movie to prove my innocence should scare the hell out of everyone in this room, and if it doesn't, then that scares the hell out of me." Adams died of a brain tumor in Ohio in 2010 at the age of 61.